Order, order. Good afternoon and welcome to today's meeting of the Joint Committee on Human Rights. We are a cross-party committee and also a joint committee, which means we have members from both the House of Commons and the House of Lords. Today we are taking evidence from a panel of 3 witnesses on the government's proposals on countering extremism, following the government's statement on Thursday last week. And we're going to be hearing from Ruth Ehrlich, Head of Policy and Campaigns at Liberty, Dame Sara, DBE, the Independent Advisor for Cohesion and Resilience, and last but most certainly not least, Joshua Rozenberg, KC, the Distinguished Legal Commentator. And we're very grateful to all 3 witnesses for joining us today. We have about an hour and a half because those of our members who are peers need to be gone by 20 to 4 for an important debate on the Rwanda bill in the Lords. So I am just going to kick off without any further formalities and ask the first question. And I wonder if I could start with you, direct the question in the first instance to you, Joshua, but invite Sara and Ruth to come in. So we know that the government has changed the definition of extremism, but it's not a legal definition as such. So I wondered if you could explain for us and those watching what change has been made, how the definition is going to be used, and what effects you think it will have in practice. Thank you.
The old definition said that extremism is vocal or active opposition to fundamental British values, including democracy, the rule of law, individual liberty, mutual respect and tolerance of different faiths and beliefs. It wasn't really a definition, it was more a summary which appeared in the glossary at the end of the 2011 report. The new definition says extremism is the promotion or advancement of an ideology based on violence, hatred or intolerance that aims to 1. Negate or destroy the fundamental rights and freedoms of others, or 2. Undermine, overturn or replace the UK's system of liberal parliamentary democracy and democratic rights, or 3. Intentionally create a permissive environment for others to achieve the results in 1 or 2. And just picking up the third point, that can be summed up as enabling the spread of extremism. And then there is guidance, ideology is defined, intolerance is defined, and there is detailed guidance from the Communities Department on what all this means. Now, it's not a legal definition in the sense that it's not in statute. It is guidance, I think, really for government departments, perhaps just for the Communities Department, the Levelling Up Department above all, which funds certain organisations within the community. So it's really a statement of intent on behalf of the government rather than a strictly legal definition as you might find in a statute. You also asked me about how it would be used and the effects in practice. The government says that the definition will be used by government departments to ensure that they're not inadvertently providing a platform, funding or legitimacy to individuals, groups or organisations which attempt to advance extremist ideologies. So, in other words, the government intends to test the organisations that it supports. The effect in practice, well, Michael Gove told MPs last week that organisations and individuals with views that are clearly extreme have nevertheless benefited from state engagement, endorsement and support. That obviously includes money, and he said there will be funding consequences for groups that fall within the extremism definition, so their money will not be provided by the state.
I think he also mentioned that there would be some sort of centre of excellence that was going to be involved in deciding who fell foul of the definition. Yes,
he did. And, we've seen this before. He obviously isn't going to have to decide this all by himself. He has his officials. I'll just find you what he said about the Centre of Excellence from his statement. But it makes sense that it's not something that he's simply doing by himself. And I should have the definition immediately. Here we are. We are also setting up a new counter-extremism centre of excellence in my department as a world-leading authority on best practice, data and research. That's really all he said about that.
I think my recollection, if I'm right is that he said it was going to be staffed by civil servants, the Centre for Excellence.
Yes, he said it will help us to understand the role played by state actors and state-linked organisations in extremist activity that's taking place in our country. The wider knowledge of what constitutes extremist behaviour and who's behind it will help us all to identify potential threats. And he said that the plans which are drawn up in collaboration with the Home Office will enable the government more clearly than ever before to establish which groups fall within the definition and support national efforts to counter the work of extremists who promote their ideologies both online and offline.
Right, and I think a Tory backbencher made a point, one of his own backbenchers, about the importance of civil service impartiality in that respect, and that's something we might return to. Can I just bring Sara and Ruth in and ask them if you'd like to add anything to that? And then I'm going to bring in Doreen, who wants to make a further point. Do you think Joshua summed it up, or is there anything you'd like to add?
So he has summed it up very nicely, actually. But just to add on a couple of points. I mean, in my former role as the Counter-Extremism Commissioner, I actually felt that the 2011 definition that Joshua has just stated was very broad, and having spoken to operational partners, they did not find it useful or helpful in any shape or form. And so I think this definition is much more narrower. I think it's more clearer. I think the bar is higher in terms of trying to capture clearly what I believe are neo-Nazi, neo-fascist and Islamist groups, some of whom were mentioned by Michael Gove in the House of Commons last week. And I think it's really important to recognise that what is the purpose of having a clear definition of extremism? And I would put forward there are three important reasons. Firstly, for those who work in the counter-extremism sector, if you can't define extremism, how on earth are you supposed to counter it or know what activity or behaviour you are countering? So it's absolutely crucial to counter-extremism efforts that we are very clear about the narrow activity that we're seeking to counter. Secondly, one of the reasons that I don't think we acknowledge enough of, actually, is that by having a clear definition of extremism, the opportunity of including people that shouldn't be included also becomes narrower. You know, if the focus is looking at lawful neo-Nazi groups and others, that it becomes more difficult to include, say, people who may hold legitimate conservative religious beliefs or any other types of views which should be protected in a liberal democracy. And finally, we have to recognise that the landscape of hateful extremism, as I call it, has changed substantially in the last decade. And in all of my reports that I produced when I was at the Commission, the nature of extremism, modern-day extremism, as we're seeing today, has evolved substantially, even in the last 10 years ago. And there's a whole range of different statistics and data indicating that it's not just an issue that's facing our country, but it's clearly an issue facing many democracies across the world, and the threat of growing mainstreaming extremism in liberal democracies. Just on a final point, when I was at the Commission, we launched one of the only public consultations on extremism, where we specifically asked the British population, what do you think of the government's 2011 definition? And 3/4 of participants and respondents, they said that they either found it unhelpful or very unhelpful. And when we spoke to practitioners on the ground, they also found it unhelpful and very unhelpful. So you've got a clearly growing problem of extremism. You had a definition that wasn't fit for purpose, and that definition was what was supporting the counter-extremism, which I reviewed and said the whole thing needed to be overturned and overhauled.
You think it's an improvement, and
Yes.
I know others, such as David Anderson, the former independent reviewer of terrorism, who thinks it's an improvement. But I think it's fair to say that not everyone thinks it's an improvement. Yes. And I think I'll bring Ruth in there. Can you tell us what you think about it?
Thank you so much. Yes, so we still have concerns about this new definition. We believe it remains vague and broad, particularly aims 2 and 3. Among our concerns, we think that the word undermine could be vague enough to potentially include strongly worded criticisms of government policy. It's unclear what would constitute a permissive environment or how intention would be assessed. And we also have concerns about the new guilt by association risk, which risks bringing people and organisations being labelled as extremists for simply engaging with other organisations, and it's simply not clear enough how that engagement is defined at this point. And I think just broadly that means that we do fear this government or future governments having the power to define groups it disagrees with as extremist. The definition as it stands now we think could sweep up broad social movements. I won't name all of them, but there are many. And we worry about the potential chilling effect that this has on civil society as a whole, which I hope we'll get an opportunity to talk about later in the session. I would also just say in terms of the practical impact, of course this definition applies mostly to DLAC and to how the government should be engaging with certain organisations or not, but we fear that it adds an extra layer of complexity to an already complex web of legislation and statutory and non-statutory guidance. And we worry, for example, about how other public bodies, including, for example, the police, would understand this definition of extremism when it comes to, for example, policing protest. So those are some of our kind of broad concerns with this definition.
Thank you. Now I'm going to bring Doreen in. I think you wanted to have a follow-up point on one of those answers, Doreen.
Yes, I think when Joshua was talking about that is the guidance. So it's really not statute or anything, it's just guidance. So my question is that who monitors this guidance? So, it seems to me just quite broad and it's out there, but who monitors it? So who knows what's going on around this guidance? And also it said it might be clear, but it still come down to monitoring, in my view. Because if you have something that the government is saying this is what it is, and they put it out as guidance, what does that mean?
And can I answer that and pick up the point that I failed to answer about the civil service? What Michael Gove said was impartial civil servants with training in this area will be supplemented in their work by studies by academics and academic bodies, and we will work with the existing expertise in the Homeland Security Analysis and Intelligence Unit within the Home Office in order to ensure that all our work is rigorous. But Baroness Lawrence's question is entirely right. Guidance is purely guidance. Ultimately, it's these officials. If groups are designated as extremist by the Secretary of State, then they can challenge this by way of judicial review. But you're absolutely right. This depends on individuals making judgments as to whether an organisation and its activities come within this definition, which is clearly more precise than it was, but is obviously open to doubt.
Thank you. That really leads me to my next question, which relates to protecting the right to freedom of belief under Article 9 of the European Convention of Human Rights, freedom of expression under Article 10, and freedom of association under Article 11, which many of us take the view that those are the foundations of our democracy, people's right to express their beliefs, people's right to hold their beliefs and express them, and people's right to associate and demonstrate. So I wonder if I could start with Ruth on this question. Do you think, Ruth, that this new definition is going to strike the right balance between addressing concerns about the types of ideology identified by the government and protecting the rights I've just mentioned?
Thank you. So the short answer is no. We're concerned about the focus on ideology in this definition rather than actions. The previous definition obviously focused on opposition with an emphasis on action, whereas the new definition focuses on the promotion or advancement of an ideology. We have real concerns about focusing on an ideology. We believe that it's dangerous. It risks interfering with people's absolute right to hold a belief as protected under Article 9. And it's important to remember it's not a crime to have violent thoughts, to hate someone, to be intolerant, if it's not tied to a specific behaviour resulting in an offence. And while that is uncomfortable, that is those are the protections that we have in human rights law. And it's not just Liberty who thinks that. The independent reviewer of terrorism legislation, Jonathan Hall, has highlighted similar concerns over the focus on ideas over action. In terms of the impact on freedom of expression, we've also got serious concerns about about the impact of this new definition. So obviously the right to have views that shock and offend is protected in human rights law, and we fear that this new definition will create a chilling effect. It will, if you're labelling organisations as extremist, it will delegitimise their views, exclude people from wider public conversation, and it will discourage people, individuals and other organisations from engaging with those organisations. And we think that this could deter people from further exercising their fundamental rights, assembly, and yes.
Joshua mentioned there the possibility of people who fall foul of this definition judicially reviewing decisions that might affect them. Do you think that the interference potentially with Article 9, 10, 11 rights could be a grounds for judicial review?
Yes, I mean, we've looked at this very lightly, and we think it could be, and we also have concerns about the public sector equality duty with this legislation as well.
Can I chip in here?
Yes,
and just make the point
Sara in.
that, as you know very well, Chair, Articles 9, 10, 11, many of the articles in the Human Rights Convention are qualified rights. Mm-hmm. In other words, the rights of the individuals have to be balanced against the rights of others. And so it's not clear how, if this were to come before a court, the rights of the people who would be bringing the challenge would be balanced against the rights of others. Michael Gove said, our definition will not affect gender-critical campaigners, those with conservative religious beliefs, trans activists, environmental protest groups, or those exercising their proper right to free speech. So we'll have to wait and see how the balance is struck. But again, one comes back to the point, this is a government definition for how the government is going to operate. This is not new law.
Sara, what's your view on whether the government have got the balance right between addressing concerns and protecting the rights I've mentioned?
I think this is a very, very difficult subject area. I mean, fundamentally, the question we have to ask ourselves is how, as a liberal democracy, can we counter extremism and extremist activity without undermining the civil liberties and the human rights, the hard-won rights that our country has established for centuries? And it's a very important question, and I think it's a question that many democracies are struggling to answer. When I did my 2021 report, Operating with Impunity, with Sir Mark Rowley, who was actually gone into retirement by then, we were very struck that actually you can square that circle. You can go after extremist activity while at the same time ensure that you are also protecting freedom of expression, freedom of worship, and all of those things. One thing I think we don't have enough of a discussion about is how extremist activity itself undermines Article 9 and Article 10, Article 11. You know, there are neo-Nazi organisations in this country like Combat 18 who are openly neo-Nazi but who don't meet the threshold for prescription orders which the Home Secretary has the power to prescribe under terrorism legislation. So you have organisations like that are openly spreading neo-Nazi ideology in this country, and they are lawful. There are other neo-Nazi organisations like the Order of Nine Angels, British National Socialist Movement, spreading incredibly destructive narratives about Jews, about Muslims, how they are attempting to replace our democracy with a neo-Nazi state. This is clearly, I think, intolerable in a liberal democracy. Now, take the example of Combat 18. That's a British neo-Nazi organisation. Other Western liberal democracies have found ways of banning them. So Germany and Canada, I know their context is different to ours, they have banned those organisations, which are not necessarily terrorist organisations, but they are clearly extremist organisations in the sense of they share the same ideology as banned, prescribed neo-Nazi groups, but who are very careful not to cross over into the terrorism threshold. So we have to be very mindful and aware that a lot of extremist groups are at the forefront of creating a chilling impact on freedom of expression, on women's rights, on the rights of homosexuals, on the rights of Jewish people and Muslim people. And throughout my entire career working in both the human rights sector and in the counter-extremism sector, that has been apparent to me time and time again, which is why one of the arguments that we put forward in the Operating with Impunity report was, if you look at Article 17 of Schedule 1 to the Human Rights Act, it makes it very clear that states have an obligation to protect itself from those extremist and totalitarian organisations that attempt to use democracy to undermine democracy itself and to undermine the rights and freedoms of the Human Rights Act. And having looked at the government's definition, I mean, I would disagree that this is an attempt to curtail belief. It is a definition that clearly talks about action and activity. It says it's the promotion or advancement. That is not something passive. That is clearly something active. The idea of negating or destroying is an active attempt. It's not something passive. Again, it's clearly not just belief. And also, if we look at footnote 5, for example, it says, based on an ideology that aims to negate or destroy the fundamental rights and freedoms. And I'm pleased that they actually took this from my Operating with Impunity report, which draws on Article 17 of Schedule 1 to the Human Rights Act. So by including that, you're making the bar incredibly high. And we know that in Article 17 cases, case law has shown that you cannot use Article 10, freedom of expression clauses, to use as an argument to undermine Article 17. So there is case law and there is precedent around this issue. What I try to do in the definition I put forward in Operating with Impunity is include Article 17 as a way to protect human rights and looking at this work through the lens of human rights, while at the same time trying to be narrower about those really dangerous extremist groups that are seeking to undermine the fundamental rights and freedoms of British citizens in this country, while at the same time ensuring we protect our liberal democracy.
Thank you. I'm going to bring Caroline in.
Thank you, Chair. I think Dame Sara has to some extent answered my question. I was going to pick up something that Ruth had said about it's not illegal to hold hateful thoughts and to express hateful thoughts or ideas, provided you're not encouraging others to do the same. And it seemed to me that it says in the definition that you have to be promoting or advancing, so actively trying to encourage others into these hateful beliefs and thoughts, or trying to promote their activities in relation to them. So I think Dame Sara to some extent answered that as a question that's an action, but you didn't seem to think, Ruth, that was the case. So I wonder if you could explain your perception of it further, please.
So our key concerns with aims 2 and 3 of the definition, that's where we think that there is the vagueness and broad definitions pose real kind of risks to how groups can operate. Again, particularly words like undermine, permissive environment, this guilt by association, those are the areas where we think that the broad definition is particularly risky. We actually think that aim 1 is much clearer, and we obviously are interested to know whether the threshold, the apparent reference to Article 17 ECHR, if the Secretary of State will be holding that definition to the same ECHR threshold. But our primary concerns with aims 2 and 3, I think as well broadly, we take issue with the government minister being able to designate groups as extremist without the due process that is involved in other processes. Obviously, we've talked about judicial review. It's extremely costly and lengthy process. Don't think that organisations should be having to undertake that risk and that process. So yeah, I hope that provides some clarity.
So for number 3, where it says intentionally create permissive environment, you think that someone simply expressing a view could be considered to be creating a permissive environment for others to express the same view?
I think it's extremely broad. I don't fully know. I don't think we fully know what it means. I don't know what a permissive environment is, and that's a problem. It's a problem for civil society. It's a problem for organisations who work with other organisations, who engage with other organisations on social media. Yeah.
Sarah, do you have any comments on that, please?
Yes, please. So I think, it's really important that the kind of further context that the government put out last week is really useful to read. I mean, from what I understand of the definition, and when I read it, it's not, you can't just read limb 2 or 3 on its own. There's clearly, other parts of it. You have to include the fact that these are people who are clearly promoting and advancing an ideology, which, for example, if you look at the definition of terrorism in the Terrorism Act 2000, it includes this idea of people who are who are motivated by or intending to advance a racial, religious, political, or any other ideological cause. What makes extremism different to any other type of activity or criminality is the fact that people are motivated by or intending to advance a particular ideology. In my view, it's one that is very much about dehumanising others as the us versus them narrative, which has existed as long as mankind itself, I'm afraid. It's part of human civilization. If you read that alongside what the other limbs are, the idea of intentionally creating a permissive environment, so you have to have intent. And as the CPS will tell you, proving intent is pretty difficult, and it's not an easy thing to do. So they would have to look at intent. They would have to bring out the evidence. Well, what is the evidence that you're doing in 1 and 2? Can you demonstrate how you are attempting to destroy the fundamental rights and freedoms, and how you're attempting to overturn, undermine, replace the UK system of liberal parliamentary democracy, which I believe we should do as much as we can to protect, because as I outlined, there are neo-Nazi and Islamist groups who are either seeking to subvert our democracy, are attempting to replace our democracy with either a neo-Nazi state or an Islamist caliphate. So that's incredibly important. And reading just the notes alongside this definition, it makes it clear also that it's looking at persistent patterns of behaviour. It's not looking at a one-off at all, which I think is really important. That's something that matters to me. Those are some of the things I raised in my report, that you have to look at intent, evidence of this type of behaviour, evidence of the ideology. It's a persistent behaviour. And I think if you've got those things, it does make it a lot more difficult to then lower the bar. But just on a kind of separate point, I do agree that I think there should be an independent oversight panel or board that is part of this unit, so to speak. I know that Michael Gove talked about academics and others, but I think as part of the quality control or quality assurance process, so to speak, there should be an independent oversight board who does the checks and balances on this. But I have to say, I understand that this is for government use only, and it's in a very narrow context. My own personal preference, as I outlined in the 2021 report, is that if we think this is such a serious threat, which I believe it is, we should actually create a legal framework. And that was one of my recommendations to the government back in 2021, that the government should commission a legal and operational framework that, in my view, is much more open, it's much more transparent. You have our judiciary that makes sure the checks and balances are in place. That is my ultimate preference. But I recognise that's quite a different issue to what the government is doing in terms of making sure it's not giving funding or legitimacy to extremist organisations.
Not just giving funding or legitimacy, it's government not speaking to organisations. So the consequences of governmental decisions to not speak to organisations could be really far-reaching for our democracy. But I want to I know Navnet wanted to come in.
Can I just make one point on that? I mean, on that point, as my current role as the Independent Advisor on Social Cohesion, my view very much is, to a certain degree, you have to engage with some extremists and those sympathetic to extremist narratives, because if the purpose of counter-extremism is not to turn people away from extremism, to win hearts and minds, to show how their narrative is so divisive, then what is the purpose of counter-extremism? It's about moving people back into the mainstream. Now, the purpose of engagement matters. If you're seeking to legitimise, that's very different. If the purpose is to engage, to draw them away from extremism, that's a very different reason. So again, it's the purpose of the engagement.
Well made. I want to bring in Navnet and then Helena, and then I'm going to go to David.
The question is basically very straightforward. If the glossary or the definition is a statement of intent, it will be very difficult to prove in court. And if the government wants to bring prescription to any such organization, would it justify particular action in the court of laws in this country?
If the government were to proscribe an organisation, it wouldn't be relying on this definition. It would be relying on the existing law or new law. I'm not sure that's a problem. As we keep saying, this is not law, this is merely guidance as to which organisations the government deals with.
Okay, Helena.
You've already indicated the importance of making distinctions between our protection of people's thinking and thought, and freedom of religion and belief is a fundamental right, and therefore the idea of thought crime is something abhorrent in a liberal democracy. What is being attempted here is to move us to something that isn't quite incitement, but is somewhere in the middle. And I just wondered if there had been any look at Scotland's law that they're bringing in, and it's in the course of going through Parliament, in relation to hate crime, where they have a stirring up offence, which is about stirring up hatred. And I would imagine this is somewhat similar to this business about creating a permissive environment for certain kinds of behaviours to be deemed acceptable or to be written off as being banter and that kind of thing. So, I mean, I wanted to ask this because I wanted us to think about this in terms of incel groups, groups who whose ideology is very much misogyny. And And I'm going to mention the names of the Tate brothers, who are currently in custody abroad, and who are wanted, and there's an effort to extradite them here for crimes. But they're very open in their embracing of misogyny, very open in their despise of women and womankind and women's aspirations to be in all places within our society. And they have huge followings amongst the young. So there's a creation of a permissive environment to basically hold a hatred for women and women's emancipation and women's participation as equals in society. Are they covered by this?
So I could tell you, I mean, when I did my 2021 report, we actually did use the incel as an example of hateful extremism. We felt that they did meet our definition and that threshold of activity just because of the fact that they are clearly inciting violence, inciting rape against women. I mean, it's horrific. So in my view, I think those that are propagating incel ideology, it's so extreme in nature, and it's about the dehumanisation and incitement and violence that I think it, you know, I mean, again, I can't say for definite whether this would meet the government's definition. It possibly could, and it would be interesting to test that, and I hope that does get tested. From my perspective, as a kind of looking at this from a policy perspective, I absolutely believe they are a hateful extremist organisation with narratives. And just on your point about hate crime legislation, I mean, one of the things that I did when I looked at the laws around, the existing laws around hateful extremism, was that we showed that there are currently gaps in legislation that is failing to deal with extremist organisations. So, you know, as a very kind of quick example, one of the things that we discovered was that it is currently lawful in Britain to glorify terrorism and to glorify terrorists and their ideologies and their actions, as long as you avoid encouraging the commission, preparation or instigation of acts of terrorism. So, well, what does this mean in practice? This means in practice, if I decided tomorrow to praise Thomas Mair, who murdered Joe Cox, said what a great guy he is, look what he did, and I could say that to children, by the way. If I wanted to praise Anders Breivik or Brenton Tarrant, who carried out the attack in New Zealand, or Robert Bowers, who carried out the attack in the synagogue and murdered Jews in America, I can glorify terrorists, but as long as I don't encourage the commission of preparation or acts of terrorism, that is currently lawful in this country. There are other gaps in legislation at the moment which is allowing extremists to operate with impunity. So it is currently lawful to intentionally stir up racial hatred as long as you avoid being threatening, abusive or insulting. So again, what does this mean in practice? This could mean that tomorrow if I decided to establish a neo-Nazi organisation, if I wanted to persistently praise the actions of Adolf Hitler, encourage members to spread Holocaust denial materials and anti-Semitic conspiracy theories, that is currently legal as long as it's not abusive, insulting or threatening. And there are a whole range of other activities which is currently caught, which is not being captured by either hate crime or counter-terrorism legislation, which we said were the two areas of law most relevant to what we called hateful extremism. But in that gap, because of that lack of legislation, you are seeing neo-Nazi groups and others operating with impunity in our country.
We've actually rehearsed that argument a lot around the business of is glorifying terrorism permissible or not? And there would be people who would be, for example, Irish Republicans who would say that what happened under the whole period of the Irish Troubles was a valuable and worthwhile thing because it brought about an end game which they would say was beneficial to the nationalist community. So it is a very difficult area, but I really wanted specifically to deal with the business of stirring up. You see, incitement, as you know, requires a high level of intent, a specific intent in relation that you intend the person to do the things that you're describing. Stirring up is a more general thing about creating what is described here, the permissive environment. And so therefore I just wondered if you had thought through all of this. I just wonder to what extent there had been some sort of serious thought about the implications of it all.
But that's exactly where extremists are operating. They are creating this climate of incitement. I mean, I read with interest how the Law Commission, I mean, we very much agreed with the Law Commission's view, which was that we should be strengthening the incitement laws more because it doesn't go far enough in capturing these extremist organisations. They're very careful not to cross over into existing stirring up offences.
I think the English Law Commission also recommended that if that was to be done, the freedom of speech defences, tailored freedom of speech defences would have to be strengthened as well to make sure that legitimate speech wasn't caught. And I just wanted to say something about the Scottish legislation, because I think in your report with Sir Mark, you recommended extending the stirring up offences under the Public Order Act to include the protected characteristic of sex, and you gave the incel example. Of course, it's the Scottish legislation doesn't include the protected characteristic of sex, and that's a subject of some debate in Scotland, which I'm engaged in myself, but I think it's worth pointing out. You recommended that down here for public order, but as things stand in Scotland at the moment, the legislation that's been brought in the 1st of April does not include the protected characteristic of sex. I think it's maybe important to make that point. I'm conscious that we've got a lot to get through, and this is such a subject that segues off into other subjects, but I want to bring David in.
Thank you, Chair, and thank you to the panel as well for helping to drill down into what we can do, what is reasonable, what isn't reasonable. And Dame Sara, I hope that you'll be able to help the committee further by perhaps giving us a note on the kind of mechanism that you described that could be done either via legislation or perhaps standalone, to give people like, for instance, the Archbishop of Canterbury and the Archbishop of York, who not normally regarded as extreme in their views, but their statement last week about their concerns about freedom of religion or belief, I think are reasonable concerns, and others have pointed out, and Ruth mentioned earlier on as well, that judicial review is a cumbersome, costly, timely process. So this idea that you put to us about having independent oversight, some way of ensuring that the right balance is struck and we achieve the objectives that you've so eloquently outlined. Perhaps if you could let us have more on that, because I personally would like to see it. But if I can take you back now to the prevent strategy for a moment. I mean, some of us feel we've been here before, first with the Labour government that introduced it, but then the coalition government in 2011, and genuine attempts to try and tackle some forms of the worst kinds of extremism. I was struck by Sir William Shawcross's review from 2023, and I wondered if you could tell us really whether this new definition is going to tackle some of the things that he identified in his recommendations and conclusions. I mean, for instance, he said it should return to its overarching objective of stopping individuals becoming terrorists or supporters. He pointed to what he called a double standard. He talked about the funding of groups that promoted extremist narratives, some, he said, including those who are sympathetic to the Taliban. He said there's a lack of training and a concerted campaign by some, including Islamist groups, to undermine and delegitimize Prevent. So how far have we travelled in dealing with his concerns? What improvements have been made between Prevent and what the government have now come forward with?
Is this for me? Or is
well, for all three of you, really. But Dame Sara, why don't you kick off?
Okay, so, I mean, just on the Archbishop of Canterbury, a man who I deeply respect, actually. I mean, interestingly, he completely endorsed my 2021 report. So he agreed with the idea that we should have a legal framework for hateful extremism, as did the Chief Rabbi, as did Qari Asim, who was the chair of the Mosques and Imams National Advisory Board. So the idea that, you know, the Archbishop and other faith leaders actually supported a legal framework, yet the Archbishop has come out against this, I think is a very interesting situation. Just as a side note, on the issue of Prevent and what William Shawcross wrote, he was right to talk about counter-extremism. I think he obviously looked at it through the lens of when extremism leads to terrorism. The harms of extremism are incredibly broad. You know, extremism can lead to terrorism, it can lead to genocide and ethnic cleansing at the very worst, but it can also undermine social cohesion, it can undermine the democratic rights and freedoms of other people, and that's just something to bear in mind. I mean, I think he is right. I think some of what this definition will do will address some of those concerns that he raised about making sure funding is not given, and rightly so. Taxpayers' money should not be given to those who are legitimising extremist narratives, organisations and others. I think that's absolutely right. So I think some of that will be dealt with. What I don't understand is how far this definition will influence Prevent as an operational strategy. That's something that's not clear. I suppose that's a question for the government really to answer, because I don't have the answer to that question.
That's helpful. Thank you. Joshua.
Well, Michael Gove did say that most extremist materials and activities are not illegal and don't meet the terrorism or the national security threshold, but extremism could lead to terrorism. So obviously Prevent, which deals with terrorism, is connected with what we're talking about now, which is extremism. He was very critical, as you recall, William Shawcross, in his report on Prevent last year. Prevent is not doing enough to counter non-violent Islamist extremism. Challenging extremist ideology should not be limited to proscribed organisations, but should also cover domestic extremists operating below the terrorism threshold who can create an environment conducive to terrorism. He was very critical of the focus of Prevent. It's out of kilter with the rest of the counter-terrorism system. He points out that Islamist extremism, in his view, represents a primary terrorist threat to this country, but 80% of the counter-terrorism police network's live investigations were Islamist, but only 22% of Prevent referrals concerned Islamism, and that suggested a loss of focus and a failure to identify warning signs. So there's clearly a problem, in his view, with Prevent, and this is only last year that he reported. But I think, again, you know, if you're talking about extremism, you're talking perhaps even as a sort of pre-crime, a crime, it's not a crime at all, but it leads to the crime of terrorism. And I do think it's important to keep the two apart, but I do think that Prevent has a lot to answer for, certainly Shawcross does.
Thank you very much. What about you, Ruth?
Yeah, thank you very much. So I think echoing what's been said by the panel already, we're not yet clear how the new definition will impact the Prevent strategy from 2011, but obviously it's unclear how you could kind of replace the statutory definition with the non-statutory definition. Our Liberty's view is obviously that this new definition is still very broad, and we fear that it will continue to compound the existing harms of the Prevent duty, which has a particular impact on the rights to freedom of expression, assembly, thought and conscience, and religion, particularly of Muslims, children and people who are neurodivergent. I would also just add, because the panel has mentioned the sort of idea that the conveyor belt theory, where people are presumed to move from having an extremist ideology to then taking part in or engaging in terrorist activity, and just wanted to touch on that. This is a theory that has been widely discredited, actually, including by the JCHR itself in 2016, who pointed out that religious conservatism by no means correlates with support for violent jihadism. The British government itself, there were documents leaked in 2010 that revealed a clear assessment that people do not progress through non-violent extremism to violent groups. And so I just think, as an organisation, Liberty has a fundamental problem with the Prevent strategy. We think it needs an independent review, and we think this is a good opportunity to have some of those conversations.
It's interesting to me as well, looking back at what Sir William wrote, that there were some softer points as well. I mentioned one of them, the training of people, but he also referred to it being used really to help people who have mental health problems, who he said, in fact, I'll quote it exactly, he said that Prevent is carrying the weight for mental health services, with vulnerable people being referred when they're in need of other forms of support. So, I mean, the cross-government, cross-departmental themes here. I mean, is this new definition taking into account things like that? They're softer questions, I know, but they do have a relevance, I think.
Michael Gove certainly said that he has consulted with the Home Office, but you've got the Home Office responsible for counter-terrorism, Prevent and so on. You've got the Levelling Up and Communities Department responsible for extremism, because I presume it's the Communities Department that funds the organisations which now stand to lose their funding. But it does seem strange that you've got separate departments dealing with two aspects of the same problem.
Joshua, would you include in that this lack of training and also a lack of confidence in sometimes dealing with some of the extremist organisations, because people have not been prepared or have the knowledge to know how to deal with people?
There's certainly problems about training. I mean, what Shawcross said was that Prevent takes an expansive approach to the extreme right wing, capturing a variety of influences that at times have been so broad it's included mildly controversial or provocative forms of mainstream right-wing leaning commentary that have no meaningful connection to terrorism or radicalisation. And if you'll forgive me, I'll quote an example that Shawcross, quotes in a footnote. I think this is meant to refer to right-wing leaning commentary. He refers to Rod Liddell, Douglas Murray and Melanie Phillips, who happens to be my wife.
Yes. I understand. Thank you very much indeed. But I think Sara wants to...
I'm really sorry, I'm going to have to move this on a bit because we have a lot of ground still to cover. And I wonder if I could ask members to maybe focus their question at one member of the panel so that I can try and bring everyone in, because we are constrained by the need for peers to go to the Lord's debate. Belle, can I bring you in there?
Thank you, Chair. The government published a counter-extremism strategy in 2015 and proposed to introduce an extremism bill on a number of occasions which never materialised. Do you think there have been any shortcomings with the government's previous approach to countering extremism?
It's Sara who complains that they didn't bring in this bill. So
funnily enough, when I gave evidence to this committee about 9 years ago, I actually came here to speak out against that extremism bill, partly because there was no definition provided by the government, and I think despite having wet towels wrapped around lawyers' heads, they couldn't actually come up with a credible definition, or at least narrow the activity and behaviours they were concerned that they wanted to outlaw. From that time onwards, I think what's happened is there's been a sense of paralysis inside government where they thought, well, we don't want to go back there and look at whether we should be legislating again around this. And that's why, partly one of the reasons why we did the legal review in 2021. I think what we tried to do was to narrow the activity, be much more, raise the bar about what it is that we're looking at, why we need to do it. And so my view, like I said, is that I think we do need a legal framework. I think it's the right thing for us to do as a liberal democracy, but also simply because I'm afraid we're failing in the struggle against extremism in this country. It's quite clear from the statistics around prevent referrals, where now I think the counter-terrorism policing said the rate of young people now being referred to prevent and being convicted for terrorist offences is the highest it's ever been on record. If you look at the scale of online extremist content and propaganda, including glorifying terrorists and I mean actual convicted terrorists who've carried out bombings that I think we can all agree are clearly terrorists, is incredibly shocking. It's literally beyond the scale. And so there's a whole range of different activities that's happening that, in my view, it does require a legal framework. But like I said, I think there's a way that you can do it which squares the extremism circle in a way that the government previously in 2015 just could not do.
I think, and maybe Ruth, would you like to say if there are any shortcomings with the government's previous approach to countering extremism?
I think what we would say is that given the number of terrorism and hate crime laws that already exist, we would be concerned about the government introducing further policy and legislation. We'd echo Robin Simcox, the Commissioner for Countering Extremism, who says that we've sort of reached the limit of what legislation can achieve in this area now. And actually, this is kind of a broader point, but we think that some of the most important ways to be challenging hateful speech is by having more speech and challenging views and having debate, and we really risk pushing some conversations further underground and making those groups harder to reach.
Can I just give you a very, very quick example of anti-Semitism, just very quickly? If I decided to send anti-Semitic tweet to a Jewish MP, that would rightfully be caught under hate crime legislation. If somebody decided to blow up a synagogue, that clearly falls under counter-terrorism legislation. But as I said earlier, if someone decided to create a neo-Nazi group that was praising Adolf Hitler, spreading dangerous anti-Semitic conspiracy theories and so forth, that is not currently being captured by either hate crime or counter-terrorism legislation for the reasons outlined in the 2021 Operating with Impunity report. So it's actually not true that we do have enough legislation. We looked at this extensively. It's clearly the case that for the types of activities I'm talking about, there is a lack of legal provision to deal with them.
Having said that, both David Anderson, the previous independent reviewer of terrorism, and Jonathan Hall, I think they think we have enough legislation in this space. And David Anderson gave a very good lecture called Extremism and the Law, where he concluded that just because extremism is a word doesn't mean it's a useful legal concept. Could that perhaps explain why the government have had such difficulty in coming up with a legal definition as opposed to this guidance?
I mean, I actually attended that lecture in 2018, 2019. I think it was a very good lecture. But this report is after that particular speech. And again, what I would just urge the committee to do is read the report for yourself and see where the gaps in legislation are. Like I said, counter-terrorism policing have endorsed this report. Many free speech activists have endorsed the report because they recognise that we have been able to protect freedom of expression and other civil liberties while also ensuring that we go after currently lawful but dangerous extremist activity.
Right, I'm going to bring Bella. Are you okay? Can I bring
no, it's okay.
Helena in there? Helena and then Jill.
Okay, yeah. I mean, to be frank, I mean, do you think that the protests that have taken place since October about the conflict in the Middle East demonstrate a need for new legal tools or a new approach to tackling extremism? I mean, is that what's generated this?
I think Michael Gove has said that it has generated this. I think that he accepts that this has spurred the government into announcing what it has done. There's also the Criminal Justice Bill, which is at its report stage in the Commons, or about to reach its report stage in the Commons. No date has been fixed for that, and the government is going to bring in a new offence to stop people purposely concealing their identities, new offence of possessing flares, fireworks and other pyrotechnics at protests, and the Prime Minister made it very clear that these proposals were very firmly rooted in pro-Palestinian protests. Rishi Sunak said that since the 7th of October attacks, we've witnessed appalling examples of anti-Semitism, support for terrorism and violent intimidation at protests across the country. So certainly this is a response by the government to what has happened, as is the proposal to bring in more legislation. Whether it's the right response is another matter.
I mean, I'd like to hear from others, because the difficulty about this is that it then is felt and experienced by the Muslim community, many of whom go on those marches every week because they're horrified by what they're seeing on their televisions, and shocked and horrified at the extent of the deaths of children. And they're there, as a humanitarian objection to all of that, and somehow being tarnished with the brush of the extremist elements that might go along, which are by far the smaller part of it, is problematic in terms of what this impact this has. I mean, there isn't a Muslim around these tables, but I mean, it is something that the Muslim community is likely to feel is a way of crushing their entitlement to protest.
Well, I could speak as a Muslim myself. I mean, I think, the head of counter-terrorism policing, Matt Jukes, said that after what happened on October 7th, it was a radicalising movement. It's going to be very unprecedented in terms of the risk of increasing hate crime, extremism, and even potentially terrorism in our country, and in our country alone. So there's clearly been a problem. My argument is that these issues well predates what happened on October the 7th and the consequent, the subsequent protests we've seen in our country. So in a nutshell, that's my particular position. I do agree with you, and I have made my position clear on this, that I think attempts to try and talk about the pro-Palestinian protests as being extremist or hate marches is actually incredibly dangerous, I think. I think you're going to marginalise mainstream voices. This is a very polarised issue anyway, and what we need to do is bring people together, not kind of make the debate even more polarising. Yeah. That's really important. And also what we don't talk about enough, and I don't think there's enough evidence being collected on this by academia or others, but the scale of censorship that is happening on both sides. We've seen some of that censorship where we know, I think it's around 89% of British Jews don't feel comfortable going into the centre of London and other places where protests are being held. But equally, I don't think we understand the scale of censorship that's being felt on those who support the pro-Palestinian side. And just in my current role, I'm very aware of academics, people working in the arts and culture sector, people who feel frightened to talk about what's happening in Palestine or Israel because of the impact it may have on their jobs, on their friendship, and all kinds of things. And that level of censorship is something we are not talking about, and we should be talking about, because there's no place for that in a free and liberal society like ours.
I'm going to bring Jill in now.
Thank you, Chair. You've touched a little bit on some of the impacts of being designated an extremist group. And Sarah, you said about it could have a positive impact because it means that we can engage with them and explain to them what they're doing wrong. And then, Joshua, you said there was a negative impact. We could withdraw funding. I'm assuming there'll be some sort of list. Is there any other impacts that you can foresee happening to these groups or their members? You know, what the effects of being designated and put on that list would be?
I mean, I think one of the challenges that I think we currently struggle with as a country is dealing with Islamist extremist groups. There are a number of Islamist extremist groups, and I'll name Cage because, again, I mean, Michael Gove named Cage, but there's been long-standing concern about Cage, which portrays itself as a kind of human rights, civil liberties organisation, and they use the argument of civil liberties as a cover for their Islamist activity. But this is an organisation that has supported convicted terrorists. It's published and invited al-Qaeda ideologues to their events and to speak at their events. They've advocated violent jihad overseas. Their senior leaders have refused to condone the stoning of women. When giving evidence to the Home Affairs Select Committee a couple of years ago, they talked about how they need to establish an EU-style Islamist caliphate. And I mean, I could go on and on and on. I mean, there's a professor of LSE of human rights.
What we really need to know, though, is what would be the effect on a group like that of being designated.
So despite an organisation like that, I find it shocking that to this day there are human rights and civil liberties organisations who choose to align themselves with organisations like Cage. You know, we would not be aligning ourselves with neo-fascist organisations, for example. But when it comes to Islamist extremist groups, we appear to have a kind of a binary, double-blind view, and it's almost as if, well, they're a minority community, we should treat them differently. And I have to say, as a Muslim, that is incredibly patronising. Yes. You know, extremism is not confined to one particular ilk of people. Because it's a human ill, you'll find it across all kinds of different races, religions, ideologies, and so forth. And so you will also find Islamist extremists present. And so
but
if it means the media don't give them support...
This definition is only about stopping the government. It's only about the government saying we are not going to engage. It won't stop other people from engaging with them.
That's true, but at least
they want it to go further than
that. But one of the outcomes will be that if they are named, then it'll be very difficult for environmentalist groups and others to then suddenly be giving legitimacy to an organisation who is doing a lot of harm to Muslim communities themselves, first and foremost.
Well, they'd be helping to create the permissive environment, wouldn't they, by normalising it?
Well, exactly.
I mean, news organisations will presumably refer to them as extremist organisations or perhaps organisations designated by the government as extremist.
Yeah. So that would be the major...
That's a very good point. They'll then be... having, in a sense, there might be a chilling effect because if news organisations and others refer to them as an organisation designated as extremist, certainly MPs and others may be quite reluctant to engage with them, so it will have a wider effect than just
it's a label around their neck.
Yes.
Thank you, Jill. Can I bring Doreen in? You wanted to come in, Doreen, there, and
to ask this question. Excuse me, I've got a bit of a cold, it's the same as you. Okay, so do you think there should be an appeal process that groups could use to challenge the designated as extremists? And I know you mentioned about judicial review, and that takes time. So do you think if there was a process that could be used to challenge, what would that be as well?
If I can chip in here, I mean, as a matter of principle, if an organisation is designated by the Secretary of State, the first thing that organisation would do would be to write back to the Secretary of State and challenge it. No doubt the department would have some sort of internal appeal process. And obviously it's expecting judicial review, and so it would have prepared its documents. It would be in a position to provide a witness statement to the court. Whether you need a separate, independent way of dealing with the question you raise, you could simply say, well, why have a middleman? Why have an intermediate process? Why not go straight to the courts after the somebody else within the department has looked again at the decision. Ultimately, it's for the Minister, it's for the Secretary of State to decide, and if the Secretary of State is firm, well, then you go to the courts.
Would you say you would like to see an independent process?
I can see the advantages of that, and it would save the cost of going to court, and maybe an independent process would be better able to decide whether an organisation was extremist or not. But then, you need more mechanism. Who's going to be on the independent organisation? What criteria do they operate, and so on? It may be simpler just to say it's a matter for the courts.
I think the unit, this new unit that Michael Gove announced, I mean, what I would hope and what would like to suggest that they do is to ensure that whenever they've collected all their evidence, that they go to that organisation and give them the right to reply and say, this is all the evidence that we've got. Can you tell us, this is a position you hold? Do you stand by it? Do you no longer hold those positions? Has your position perhaps changed? I think all of that and giving those organisations a right to reply has to be part of that process. I think that's only fair for that. And like I said, I think then as part of that there should be an independent panel or board who then looks at it in the final stage or round. I mean, that's how I would do it if it was me. Yeah. But I think it's really important that you give organisations the right to reply and you put the evidence to them and allow them the right to give their thoughts and views on it.
Yeah, I agree.
Ruth, would you have any things to say? Where would Liberty sit with all of that?
So again, we don't really agree in principle with creating a power for a government minister to design certain groups as extremists. But if that exists, then of course we do think that those people, organisations should benefit from due process, from a proper appeals process that's independent. Certainly, when we get into looking at judicial review, there are, as we well know, questions of inaccessibility, of cost, that are simply going to be prohibitive for lots of particularly smaller organisations.
Simon, you wanted to come in there.
Yes, so just on the question of an appeal, I rather agree with Dame Sara what you've said about there being a mechanism by which evidence is presented to a party before they're named, so that they can make submissions on it. I think that would be consistent with open justice, but it's possible that the Home Secretary would be relying on closed evidence, and I can see that would give rise to certain issues in that context. So clearly any system would need to be flexible enough to admit of that possibility. And I think I probably agree with Joshua too, and I'd be interested to hear your thoughts on this. If there was to be an appeals process, it seems to me that the only way that could be done would be to have some sort of legislative framework. And then we come back to the question of, do we need legislation? If we simply have an extra a guidance definition as we have now, then there can't then be a statutory appeal process on top of guidance. So it seems to me that we have to decide one way or the other which route we're going to adopt, and we've gone down the non-statutory route. Therefore, there can't be a statutory appeal process, and therefore we're left with judicial review. Is that something, an assertion you agree with, Joshua?
If you look at what the Crown Prosecution Service does, it has a victim's right of review of a decision not to bring a prosecution. Mm-hmm. And what that means is that the decision not to bring a prosecution is reviewed by somebody more senior within the Crown Prosecution Service. On the same criteria, but it's a fresh pair of eyes. It's not statutory, it's just another chance for somebody else to look at the papers again and think, did the person one rank below me get the wrong decision? But ultimately, it's for the Director of Public Prosecutions to decide. So you could say that within the government department that designates somebody as extremism, which I presume would be the Communities Department, then senior officials take a decision which may be endorsed by the Secretary of State, but if you were to challenge it, then a more senior official or a separate official from another part of the department looks at it again. Ultimately, though, the Secretary of State has to take the decision on the advice of officials, but you could at least have different officials reconsidering it if there was an appeal, effectively, by the organisation.
Ruth, would that satisfy Liberty's concerns to have an internal, non-judicial, if you like, appeal system?
So again, we disagree with the fundamental principle that the Minister has this power, so it's not really one for us to comment on in detail.
Lord Delakia, can I bring you in there? If you've got another question about the risks of the implications of potential legal challenges here.
There's a risk or if groups or individuals were to bring any challenges on the basis of reputational damage, particularly in relation to being designated as extremists. Do you see this as a possibility?
There's a risk to the Secretary of State in designating an organisation as extremist. There's a risk to the Secretary of State in deciding not to designate an organisation as extremist. It's a matter of judgment, which is what ministers have to exercise. It's not going to lead to libel if their decision is privileged. If they say things outside the protection of parliamentary privilege about an organisation, presumably they could be sued, but the government would presumably pay for them to be defended in court. It is a reputational matter for ministers because they've got to take difficult choices. But that's what ministers do.
What do you think, Sara?
I agree with what Joshua has said. I don't disagree with anything he said there. I think what I would just add as an additional point is that one of the challenges for those working in the counter-extremism sector is there is an increasing tactic being used by clearly extremist organisations to sue and use libel law to silence anybody, including sections of the press, trying to silence them. I've heard countless examples of journalists, for example, who, in their lawful business of reporting and investigating on extremist groups, have been met, abuse, threats of taking legal action against them, trying to censor and silence them. And so again, I think this is again one of why I think a legal framework is more helpful, because to do that you overcome the issue about libel law, and which at the moment is, I think, constraining parts of counter-extremism efforts in this country.
On the other hand, people have a legitimate right to defend their reputation.
Yeah, that's true.
If somebody feels that they have been wrongly labelled an extremist when they are merely trying to contribute to the democratic debate, surely they have a right to seek redress.
I completely agree. The challenge is when you've got extremist groups who are... the tactics of extremists have changed substantially in the last 10 years. Like I said earlier, they use the language of human rights, civil liberties, freedom of expression as a cover to promote their hateful language as an extremist narrative. It is incredibly complex, incredibly difficult. What I've seen in my career is that that's what they do repeatedly, both on the neo-Nazi side and on the Islamist side, that they will regularly use libel law to try and shut down any attempt to investigate or report on their activity. And again, that's why I think a legal framework would be a better way of managing this issue.
I wonder, Ruth, have you got a different perspective on this? Some organisations might not be able to afford to take a libel action.
Yeah, so libel law is definitely not our area, but we do think it would be possible for individual groups to bring challenges on the basis of reputational damage. I alluded to this earlier, but we think there may also be challenges on the basis of the Equality Act. So we think the policy could be at risk of breaching the public sector equality duty under Section 149 of the Equality Act. That's on the basis that the government must have due regard to advance equality of opportunity and foster good relations between people with protected characteristics and those without. We think there may be a legal argument there that this policy, this definition would breach that. So yes, that's in terms of the legal challenges.
Thank you. Simon.
Sorry, just on the libel point, if I can go back to that. Just focusing on the issue that's before the committee about this definition. If the Secretary of State were to designate a certain group as being extremist for the purposes of this policy, and they then, instead of challenging it by judicial review, decided to bring a libel claim, saying that the reputation of those involved had been lowered in the eyes of right-thinking people, it seems to me it wouldn't be very difficult for the Secretary of State to run a defence of fair comment and produce the evidence. So it's highly unlikely that a libel claim is going to prevent the Secretary of State designating, and it's not as if the Secretary of State is short of resources in terms of defending that libel claim.
No, I agree, and there may be political advantage to the Secretary of State if the Secretary of State does actually manage to limit extremism, which is, after all, what we're talking about.
Exactly.
Sara, do you want to come in there?
Well, I want to ask Dame Sara first, in the first instance, just where we're getting on this. Your preference is obviously for if you're going to have a non-statutory definition, for it to be tighter. You made that clear. But your real preference is there for to be more statutory involvement in this area. I just want to ask you whether the government, by doing this sort of non-statutory guidance, is rather nebulous. What does it really mean? Are we as a society forgetting that what we should be doing is to work through civil society first? And are these issues just a symptom of what we've not been doing for years? So why go for the statutory, further statutory involvement, which is your preference? Why not concentrate on rebuilding civil society and allowing people to say things which are outrageous and not effectively criminalising them all the time?
So, I think that the definition is just one tiny aspect, actually. When we talk about what does counter-extremism look like, it's not just one thing, it's a multifaceted thing. I think there has to be non-legal and legal measures. So I've discussed a lot about the legal framework that I think is needed. But ultimately what you also need is a counter-extremism strategy where you engage with people who are sympathetic to extremist narratives. You don't criminalise them. You don't kind of push them in a corner and say, we don't want to engage with you. It's about engaging them, like I said, bringing them back in to the mainstream. I strongly believe that we need to focus much more on social cohesion efforts. I think in the last couple of years that has just fallen to the wayside, which is really disappointing. Even with the recent debates about the pro-Palestinian demonstrations and the tensions between Israeli and Muslim communities in this country and Jewish communities and others, there's been so much focus on the policing, the kind of downstream issues rather than the upstream social cohesion efforts. And actually, what are we doing to overcome those tensions that were clearly there prior to October the 7th and so forth. So I think we need a much more rigorous social cohesion approach and social cohesion strategy, as well as a legal framework, as well as dealing with a non-statutory counter-extremism strategy. To be clear, the government scrapped the 2015 counter-extremism strategy in 2021. Nothing has replaced it since. So there are clear gaps in the way we deal with extremism as a whole. And the definition is just one tiny part of that. Unless we have all the other jigsaw pieces, I'm afraid our approach to counter-extremism is, as I said earlier, behind the curve.
So rather than focusing on extremists, should we not be focusing on wider society and our education, how we rebuild relations?
I think you need both. I don't think you can focus on one or the other. I always envisage it as almost like three nets. If you think of terrorism, and then you've got counter-terrorism initiatives, you've got counter-extremism initiatives as a separate net, and then you've got social cohesion. Some people will just go past the cohesion issue. No matter what you say or do, they will still never feel they belong to this country. They will always view our country as being an enemy, as hostile. You then have to capture them through other means, and I think that's where you capture them through the counter-extremism net. But you need a different strategy and approach. The counter-extremism strategy has to be different to a cohesion strategy. There are two different things. And I think unless you have all of that, alongside a definition and all the other issues that I've raised, only then will you get anywhere near to kind of scratching the surface in dealing with extremism. The social cohesion side is imperative, and we don't talk about that enough. We don't talk about how do we bring people in, how do we build and promote the fundamental rights and freedoms about the rule of law, all the things that we celebrate as a nation, and all the things what does it mean to live in a diverse democracy as ours. I think those are really important questions, and I think sadly, as I said earlier, that it just seems to have fallen. It's just been ignored, I think, in the last couple of years, and it's something that I am looking at publishing more details on in the forthcoming few weeks.
Is it not fair to say you've not actually had substantial responses to your report? So I think that's what you told the Home Office, the Home Affairs Committee.
I've had no response from the Home Office to any of my counter-extremism reports when I was at the Commission.
This has come along, but this has come along over across the piece, but you still haven't had a response.
No.
Okay.
Make sure
it's not just what's happened in the past couple of years. This is a journey of 30, 40 years. It's a post-war journey. Are we throwing the baby out with the bathwater to think that just a definition or even a new law could solve this? Isn't it more fundamental?
No, I agree. That's what I'm saying. That's why I think we do need to focus on social cohesion. Let's be clear. Since 2001, there have been 20 years' worth of social cohesion reports in this country, and there have been numerous recommendations. The last report was done by Dame Louise Casey in 2016. All of those reports were incredibly important. How far have we come in devising a really credible social cohesion infrastructure in this country? What are we doing to make sure that despite our differences, we're able to get along well together? And I think actually some of the tensions we're seeing is increasingly becoming quite worrying. I mean, the abuse that parliamentarians are experiencing, the growing climate of censorship, the growing climate of harassment people are experiencing, there is a tension there which I don't think we're addressing fully. And again, I mean, some of this I'll be highlighting in my forthcoming report, which I'd be very interested to hear your thoughts and views on once published.
If we start with what the government's doing, if they are just taking a guidance route, what extra could they do by way of measures which aren't statutory?
Michael Gove in the House of Commons last week said that the definition was just the first in a series of announcements around counter-extremism. I think he mentioned religious hatred. I think he also mentioned social cohesion, which I was pleased to see. So, I'm interested to see what they're going to say about all of those things as well. But I'm glad that they've at least acknowledged that the definition is just one part, but it's definitely not the whole part. And we have to see what else the government's going to do on all of these really incredibly important issues.
Yeah, we have
and you mentioned your work with Sir Mark Rowley. Can I ask you what you think the problem has been about the marches in the way that they've whipped up upset from all communities? What could be done operationally differently in your view? And then, of course, I'd like to hear from Ruth and Joshua.
So, obviously the Home Affairs Select Committee, I think, did an excellent report on this. My concerns particularly have been around the initial kind of celebratory they're not protests, but celebratory kind of events that we saw literally on October the 7th and the 8th onwards. They were clearly not protests. They were something of a different category that was celebrating the murder and the horrific attack of Israelis in October the 7th and Jewish people in Israel on that day. I think after that, we've also seen Islamist extremist organisations like Hizb ut-Tahrir. Again, this is an organisation that's been lawful in our country for 40 years, who have actively oppose democratic norms, who believe in the establishment of a theocratic caliphate, who do not subscribe to any idea of human rights or civil liberties. We saw them chanting jihad out on the streets. And my own view is that if we did have hateful extremism prescription orders, separate to terrorism prescription orders, we would have not seen them on the streets chanting jihad, creating that kind of climate and incitement against Jewish people and others. And so I think there are ways that we could have handled this better if we did have a legal framework. But again, like I've said earlier, many of these protests are overwhelmingly peaceful. And the police have Met Police have made that clear, and I think it's really important that people do have the right to protest in our country. That's a fundamental right for people in this country, and we have to make sure we protect that and don't conflate them or suggest somehow they're all hate marches or extremist marches. That is completely counterproductive.
Is it a question of numbers rather than glorification? Are we able as a society to accept a certain sort of protest that veers on glorification if it's smaller in number? Is it a numbers game, the fact that it's so overwhelming that the numbers take over the whole city and people say that they're frightened to go out at the weekend? So is it a numbers game rather than the actual, what you're seeing at the protest?
That's possible. I don't know whether Joshua...
Numbers are important. One could restrict the number of people who attend a march or a demonstration. Police have various powers. It's a bit difficult to say, well, a lot of people are protesting, but we're only going to let some of them protest. But on the other hand, you do have the practicalities. If one cannot get along the street outside this building, if you, as members of Parliament, House of Commons, House of Lords, can't get into or out of this building because there are too many protesters outside, if I can't walk past Parliament, if I need to go from the tube station to the BBC studios, for example, that's a matter of concern. Personally, as it's widely known that I'm Jewish, I certainly wouldn't go anywhere near one of these demonstrations, and I wouldn't wander around that part of London on a Saturday afternoon because I have no wish to encounter the people who might be on that demonstration. I presume I'd be perfectly safe, but I don't want to give it a chance. You've also got the whole question about projecting a slogan on the Victoria Tower, on Big Ben. It doesn't harm me. It offends me. It's support for a proscribed terrorist organisation according to any definition of the slogan that was there. I think it's something that should be prevented. I think it does frighten and disturb members of the Jewish community and the wider community as well. So it is a matter of concern. Equally, Sara is entirely right. People are entitled to protest. And just to final point, to endorse what Sara said about the demonstrations immediately after the attacks on October 7th. There was one the following day, a Sunday. That and those that followed it immediately afterwards cannot have been to protest against Israel's response to the murderous attacks on people in Israel. 1,200 killed, kidnapped, raped, appalling atrocities, because of course the response didn't happen for another 3 weeks. So it's very clear to me what those people were saying. They must have been inevitably supporting these murderous attacks on people in Israel.
How do you control...
Can I just bring Ruth in there, because I know you wanted to make a comment.
Ruth needs to say.
I'm conscious of the time.
Thank you. I have much to say on this, and I'm wondering where to narrow down into. But obviously the events of October 7th and subsequent events in Gaza have caused immense pain for many communities across the country, and we've seen an astonishing and really distressing rise in anti-Semitism, Islamophobia, anti-Palestinian racism. I don't think that rhetoric from many places has been particularly helpful in encouraging cohesion, including from some members of the cabinet, past and present. I think it's extremely dangerous when we're entering into a territory where we're conflating all protesters with a minority who hold extremist views, as has already been touched on. And at Liberty, we feel concerned about the government using a moment of deep crisis and hurt for many communities to push through further restrictions on our civil liberties, particularly when we think about public order. The government has passed 2 enormous pieces of legislation that restrict rights to protest through the Police Crime Sentencing and Courts Act of 2022, Public Order Act 2023, and subsequent serious disruption regulations. We disagreed with many of the parts of these acts, but it's shocking that the government is now using this moment to try and push through even further powers through the Criminal Justice Bill. We think it's really important that people are alive to the fact that our civil liberties are being eroded, because there is a highly febrile, stressful and upsetting external environment going on. And I would really exercise caution. Hundreds of thousands of people are taking to the streets. Communities aren't a monolith. There are lots of different people out there. And I think it's really important that we don't allow this moment to be monopolised and used to strip back our civil liberties.
Eleanor, I think you just wanted to come in briefly on that point.
I wanted to pick up with what Ruth Ehrlich has just said, is that the business of the timing, isn't it likely to accelerate that concern amongst our Muslim communities up and down the country, that this is disproportionately responding to them, that this is about them. And I think that many Muslim organisations have that sense that this is about a taking of sides, and therefore, far from creating community cohesion and so on, which is particularly needed given the divisions there are in our society, that this is actually particularly about the timing and particularly about how it's put together and who will be on the lists. All I'm saying is that isn't this going to be seen as being disproportionate to one section of our society? Don't you think that, Dame Sara?
I think if you look at the definition, in my view, is ideologically blind. I think it's very hard to try and pin this
timing.
down.
The timing is of the essence here.
I can't comment on that. That's not something that I can comment on.
I'm going to bring Joshua in because you wanted to answer.
Can I just make a point about Muslim communities?
I am going to bring Joshua in because the difficulty I have is I have to let the peers go to the chamber for the Rwanda debate or they won't get to speak. And I know I just wanted to bring Joshua in, and then I'm going to have to draw it to a close. Maybe send some follow-up questions to you because this is such a rich area.
The short answer to Lady Kennedy's question is yes, this is about them. The Secretary of State named the British National Socialist Movement and Patriotic Alternative. I don't think they get much funding from the government. The other organisations were Islamist organisations, not Muslim organisations, but Islamist organisations in the Secretary of State's definition. So yes, it is about them.
I mean, I would disagree with that. Yeah. I think it's much more complicated than that. And actually, when we talk, like Ruth mentioned earlier, communities are not monolithic. There are many Muslim voices in this country who feel threatened by Islamist extremism, who feel very disheartened at the fact that the government has not done enough on Islamist extremism because it's their children that are being radicalised, that are, who are dragged into to all kinds of conflicts where there are hate preachers targeting their children.
Their children are also being demonised, and that's what they're feeling very anxious about at this moment in time.
I agree, but I think that's what the government is doing about anti-Muslim hatred is a legitimate concern. I would like to see the government do more on this issue. I don't think they have done enough on this issue. But at the same time, that doesn't mean we should not tackle the threat of extremism, including Islamist extremism.
I'm going to have to draw this very interesting session to a close because of the timing of the debate in the Lords. So can I thank our witnesses and indicate that if you feel there was anything you wanted to say and you haven't had the chance to say it, please feel free to write to us. And if we go back and realise we've left something crucial out, we may write to you. And this is an issue that we will definitely be revisiting. But thank you very much for your time today. Order, order.
The proceeding has ended. 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 The proceeding has ended.